5 seconds to go. Start. In cases where evidence is of a circumstantial nature, the circumstances from which the conclusion of guilt is to be drawn should, in the first instance, be fully established. Stop. Each fact sought to be relied upon must be proved individually. Stop. However, in applying this principle, a distinction must be made between facts called primary or basic on the one hand and inference of facts to be drawn from them on the other. Stop. In regard to proof of primary facts, the court has to judge the evidence and decide whether that evidence proves a particular fact, and if that fact is proved, the question whether that fact leads to an inference of guilt of the accused person should be considered. Stop. In dealing with this aspect of the problem, the doctrine of benefit of doubt applies. Stop. Although there should not be any missing links in the case, yet it is not essential that each of the links must appear on the surface of the evidence adduced, and some of these links may have to be inferred from the proved facts. Stop. In drawing these inferences, the court must have regard to the common course of natural events and to human conduct and their relations to the facts of the particular case. Stop. The court thereafter has to consider the effect of proved facts. Stop. Para. In deciding the sufficiency of the circumstantial evidence for the purpose of conviction, the court has to consider the total cumulative effect of all the proved facts, each one of which reinforces the conclusion of guilt, and if the combined effect of all these facts taken together is conclusive in establishing the guilt of the accused, the conviction would be justified, even though it may be that one or more of these facts by itself or themselves is oblique are not decisive. Stop. The facts established should be consistent only with the hypothesis of the guilt of the accused and should exclude every hypothesis except the one so to be proved. Stop. But this does not mean that before the prosecution can succeed in a case resting upon circumstantial evidence alone, it must exclude each and every hypothesis suggested by the accused, howsoever extravagant and fanciful it might be. Stop. There must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused, where various links in chain are in themselves complete, then the false plea or false defense may be called into aid only to lend assurance to the court. Stop. Para. A similar view is taken by this court in the subsequent decisions in the case of Muhammad Yunus Supra and Anwar Ali and another Supra. Applying the law laid down by this court in the aforesaid decisions to the facts of the case on hand, it is to be considered, whether in the facts and circumstances of the case, the High Court and the trial court are justified in convicting the accused for the offence punishable under section 302 and 34 of the IPC. Sign of interrogation. Stop.